Transitional provisions under GST Law Part 3 Input credit available for exempt services and goods. Background. In India, many states do not require VAT registration if the turnover does not cross certain threshold. For example, in Karnataka, there is no need to get VAT registration if the turnover does not cross 10 Indian rupees lakhs. In such a scenario, question arises whether input credit can be availed on goods lying in stock under GST law. Similarly, if you are a service provider and providing exempt services, or a manufacturer who produces exempted goods, then again the question arises whether input credit can be availed on goods lying in stock under GST law. Specific provisions under GST law. The above scenarios are covered by Section 169 of GST law, which says that a registered taxable person, who was not liable to be registered under the earlier law, or who was engaged in the manufacture of exempted goods or provision of exempted services, or who was providing works contract service and was availing of the benefit of Notification Number 26/2012 Service Tax, dated the 20th of June 2012, or a first-stage dealer or a second-stage dealer or a registered importer, shall be entitled to take, in his electronic credit ledger, credit of eligible duties and taxes in respect of inputs held in stock and inputs contained in semi-finished or finished goods held in stock on the appointed day, subject to the following conditions. Such inputs and/or goods are used or intended to be used for making taxable supplies under this Act. The said taxable person passes on the benefit of such credit by way of reduced prices to the recipient. The said taxable person is eligible for input tax credit on such inputs under this Act. The said taxable person is in possession of invoice and/or other prescribed documents evidencing payment of duty under the earlier law in respect of such inputs. Such invoices and/or other prescribed documents were issued not earlier than 12 months immediately preceding the appointed day. And the supplier of services is not eligible for any abatement under the Act. Practical application of the provisions. Let's say ABCD is a dealer who was not liable to register under VAT, as his turnover was below 10 Indian rupees lakhs. In financial year 2017 to 2018, he is expecting his turnover to be 40 Indian rupees lakhs. Therefore wants to get registered under GST law. Let's assume GST is effective 1st of April 2017. ABCD has stocks worth 2 Indian rupees and 50 lakhs on which VAT paid was 20,000 Indian rupees. In this case, ABCD can claim input of 20,000 Indian rupees under GST, provided that conditions as prescribed in Section 169 are met.